Greetings and welcome to Calabash Community Talk with me, Ramotse Jonathan. This is still that community talk where we're talking to bringing to you the issues that affect the community. And on Tuesdays, remember, we're talking to the people about the small businesses, not only small businesses, but the businesses we feel for this ones we can profile on our platform. We also on Wednesday speak to the ward councillors and the PR councillors from different municipalities. We've been concentrating on the city of Johannesburg. We're promising that in the next coming month we'll be able to go to other areas and speak to their councillors about this delivery and other issues in things. But today is Thursday. We're speaking to Kwazi Dlamini, who's going to talk to us about the issues that labor. Most of us, we get affected by these issues in our workplaces and we never know how to go around them. And she's here. And Kwazi she's from Nel Mondi Consulting mo eleng gore le bona ba thusana ka di issues that got to do with HR. These are the people ba eleng gore le ka ba contact as the businesses la bua le bona. She will be giving you the contact details tsa bone at the end of the day. But Rona now will be before we start nako ya rona, let me remind you gore you can still assist us to build this community, assist us to build this community, a Calabash Community Network, by subscribing on this platform to become a member. Now subscribe and don't forget to press that notification button. But if you like audio, we're still on Spotify where you can get the audio. Yeah, there's both Spotify and Amazon Music. You can get this interview and then but without wasting time, let me introduce the topic Yarona and also welcome Ozgwazi. Ozgwazi, welcome to Calabash Community Talk. What are we talking about today?
Oh, Jonathan, firstly, good morning or good day, thank you for inviting us again. Today we will be talking about misconduct in the workplace and when employees are dismissed on account of misconduct. That's our focus today.
You know, misconduct is one of those things. When you are at work, sometimes you will think you're doing something and you're doing something wrong, and they tell you this is a misconduct. Then you end up being called to that HR office, and you get that warning letter or whatever disciplinary measures somebody uses. Let's unpack misconduct. What is misconduct?
Yes, so misconduct is wrongdoing. It is something that the employee would have done to break the rule of the employer that exists in that particular organization. And so, which is why we stated the importance of employers ensuring that employees are aware about the rules of the company. What's also very important, Jonathan, to note is that a disciplinary code where those rules are contained, it must be very easy for employees to understand. It doesn't help, Jonathan, for the company to have a fancy document that no one understands. But it must be in a very clear and simple language that anyone from a so-called lower ranked position to the highest in the organization, they all have to understand, because it's a document that speaks to how they should conduct themselves in the workplace. So that's when we say that when an employee has broken that rule of the employer, that is called a misconduct.
When you talk about the document being one of the simplest things for an employee to understand, it takes me back to what I asked the last time. Isn't it important that the employees that play a role there, because we bring the high professionals who speak the high English? Most of the people company, they don't understand that. But if you involve the people who are working for that company, they will be involved. A simple language then will be used for that.
I hear you on that point, Jonathan, in terms of their participation. And of course, it must be noted that the environment itself should allow for employees to raise those things, to say, you know what, we see the document that you have, but this document doesn't speak to me. I don't understand this document. It is the employee's right to state that. Because remember, if it's a rule that I must abide by, at the very least, Make me understand the rule. So nothing stops employees from raising those points to say, employer, your disciplinary code is not clear. Make it clearer for us to understand. So there's absolutely nothing wrong with that, Jonathan. If anything, we encourage that employees do that or raise that with the employer.
So if they come tomorrow, Togon, and say, Jonathan, this is your first misconduct, what is the first thing that an employer must do?
Sorry, can you just
when they come to
again?
me and say there's a misconduct that we have done, what is the first thing that the employer must do to make sure that we remedy the situation?
All right. So you are bringing up quite an important point that I want us to discuss. So the first thing is to engage with the employee on that particular rule that they would have broken. So one of the things that I mentioned yesterday in our last sitting is that when we consider what an employee has done, we need to look at the nature of the offense. And the nature of the offense itself, we look at what is the appropriate sanction in dealing with that particular misconduct. For instance, something as simple as leaving work early. You know, sometimes employees don't think that is actually something wrong that they are doing. I'm supposed to leave at 4 and I leave at 3:30 without authorization, without talking to my line manager about it. It's actually an offense, because in terms of our contracts, let's say I start from 7 until 4, I must leave, meaning I must stop working at 4 o'clock and only leave thereafter. So what we do is we look at the nature of the offense that the employee has committed, and we look at what the disciplinary code recommends that we do as an employer in rectifying that behavior. So you find that for an offense like that, which is what we call a non-serious misconduct, we then say, okay, for this offense, we can do what is called progressive discipline. Meaning, progressive discipline is applied for non-serious misconduct. Coming back to your point, Jonathan, this employee has committed, let's say, a non-serious misconduct, such as reporting late or leaving work early. And we find that in terms of the disciplinary code, when the employee commits that offense for the first time, they can actually be issued with a verbal warning. And we start small like that. We issue the verbal warning to say to the employee, don't do that again. That, Jonathan, is an example of correcting the behavior of the employee. So that's what the employer
So
does.
you talk about progressive discipline. How long should I, as an employer, engage in this progressive discipline? You come late today, I say to you, I'm giving you verbal warning. Then tomorrow you come early, but what you do, you something different. To that, do I still give you a verbal warning? Because conduct is two different things. And how do we engage? How long should the employer engage in this progressive discipline?
All right. So let me then put it this way. Thank you for that question, a very valid one as well. So Jonathan, so I'm here. Let's say I reported late for duty today. You issue me with a verbal warning, Kwazi, don't come late again. And I say, I understand I was wrong, and I sign the verbal warning. And then verbal warnings are normally valid for a period of 3 months. And then within this 3 months, there I am, rocking up late again. And you are coming back to me again to say, but Kwazi, what happened now? What happened this time? No, Jonathan, it just happened. I woke up late. That kind of story that I'm giving you. And you say to me, but we've spoken. And I say, I promise it won't happen again. And then you issue me now with a written warning. So as we build up, sanctions become harsher. So a written warning is much harsher than a verbal warning. A verbal warning is normally valid for 3 months, and then a written warning now is valid for 6 months. So now I'm sitting with a written warning for the next 6 months, meaning At all costs, I must ensure that I don't repeat this offense again. And then again, within that 6-month period, I still commit the same offense again, and I'm giving you stories, Jonathan. At that point, Jonathan, then you give me now a harsher sanction, which is what is called a final written warning. Now, a final written warning is my last opportunity to get my act together. Because if I, and normally, and it depends, some companies have final written warnings that are valid for a period of 9 months. Other companies have final written warnings that are valid for a period of 12 months. So it means within that period of the validity of the final written warning, I cannot do this again. But then guess what? I repeat the same offense again. You take me through a disciplinary inquiry. I sit in front of a chairperson. What does Jonathan do? Jonathan brings all the warnings that he has given to me that will show the chairperson that you've spoken to me. I'm aware of the rule. You have tried as an employer to rectify my behavior, but for some reason I cannot be rehabilitated. And that is where then the decision will be made to say, at this point, the employee does not change their behavior, therefore dismissal is our option. So that's a build-up when we are talking about progressive discipline. But we must note again that not all offenses allow us to apply progressive discipline, which is why we stated that the nature of offense will always inform us what we must do. We will not treat late coming the same way as we would theft, for instance. With theft, if the company is able really to prove that you've committed that offense, it warrants a dismissal, even when the employee has committed a very serious offense.
Before we go to my next question that still talks about the dismissal, I want clarity on this one. The verbal warning.
Yes.
Do we sign for that verbal warning? Because most administratively, the small businesses will not understand whether we sign for that or not. Do we sign for that? And as the proof that when to the next to the hearings, we're able to say yes, we had this verbal warning that was given to this employee.
Yes. It's very important to document communication, Jonathan. It doesn't have to be fancy, but when it's documented and both parties sign that they have indeed engaged on this issue, it helps to prove it in future when the employee does not change their behavior. What may also be a question that may be asked is, what happens if the employee refuses to sign that warning? Because sometimes they do refuse. In that instance, Jonathan, you can get somebody, preferably at the same level as the line manager or the supervisor, to come in and sign as a witness that the employee has refused to sign this verbal warning. And so it will be the line manager who signs as well as the witness who signs, so that we can show in the future that we intended to issue this warning to the employee, but they refused. So it must be noted that just because an employee refuses to sign the warning, it doesn't deem the warning invalid. It is still valid, and we get a witness
So
to
we
sign.
were in the hearing, we've produced all the evidence that we needed to produce to the chairperson of the hearing, and the verdict comes, it says dismissal, and then the employee leaves. Can the employee still appeal internally to say, as a company, these are the reasons why you must not let go of me?
So it will depend, Jonathan, on whether or not that particular company has that process in place. It allows for such a process in place. So not all companies have the appeal process as one of the mechanisms of dealing with discipline when an employee has been dismissed. So it will depend on each company what processes they have in relation to.
In the absence
to the
of that
appeal,
process, what is my recourse as an employee?
Then when the employee when that recourse is not available to the employee can then refer a dispute to the CCMA or the relevant bargaining council and lodge a dispute there within 30 days.
But when you
from the
go
date
to the
that they were dismissed.
CCMA, an employee will be there alone, and the company will bring all those people, the experts, and in most cases there are issues that they work as a disadvantage when it comes to an employee. Are they allowed to get a representative when they go there?
So yes, they can. I will explain it in two ways how they can do that. So one, let's say I've been dismissed and I was a member of a union, a trade union. I can get my trade union official to accompany me at the CCMA when I go there. If I wasn't and I'm not part of any trade union, others may seek legal representation. But still, legal representation is not automatically granted at the CCMA. That particular employee, at that point, they'll be called an applicant, can then get their lawyer to apply for legal representation. And of course, they will state reasons thereof. And the commissioner who is dealing with that particular case will consider that and consider what the employer says if they intend on opposing that application. But it is up to the commissioner to make a ruling whether or not legal representation for the applicant, who is now the former employee, whether or not it's granted. So they can.
Before we go to the grounds for misconduct, two questions. The first is, what happens if I can afford a lawyer? Can I bring my uncle who understands these issues and say, come and be my legal representative? And at what point do we then do dedication?
Okay. So when you talk about
externally at the CCMA,
are you talking internally for the inquiry or externally? At the CCMA.
Okay.
So if it's so you can't just get your uncle. It's either you're a trade union official or you are an actual lawyer, because that has to be verified.
Anybody.
So it's very important that you don't just get anybody. It has to either be yes. So it has to be an actual attorney, or you get your trade union
what
official.
What are the grounds for dismissal? Yeah, any employee or long faces the charges. Let's start in more company in Gaboyone.
Okay. So in terms of grounds for dismissal, so there are three grounds to which an employee can actually be dismissed. So we've just tackled one now, which speaks to misconduct. But there are two other reasons to which an employee can be dismissed other than for committing misconduct. The second one is that an employee can be dismissed on grounds of incapacity. Now, incapacity simply means that the employee is incapable or no longer able to do the job that they have been employed to do. And within incapacity, it's actually broken into two on its own. So incapacity has two legs. So one can be incapacitated due to ill health, meaning that my health does not allow me to continue to do the job that I was employed to do. Or number two, due to poor work performance, meaning I'm simply just incapable of doing the work. And what that entails is that I have been employed in this position and I just seem to not be able to do this job. Even though the company has trained me, even though the company has coached me, did all sorts of interventions to assist me to be able to do the job, I simply cannot do it. So it's not that I don't want to do it, it's just that I just seem to not be able to do it. So in one of our topics, we will be able to explore both the areas of incapacity, what they speak to. But in a nutshell, incapacity is about an employee who is not able to do the work that they were employed to do. So that's another reason. So all of that has to be investigated
we talk about in incapacity, and you mentioned the two, if I can say the two legs of incapacity. I apply for a job and it's been advertised there, and I go for an interview. I impress the employers, and 6 months down the line they realize that this person can actually do this job. Are they obliged to offer me training or coaching so that we mitigate the situation, or they can say we letting you go because you can't do this job?
Yes, great question, Jonathan. So that question has to be answered in two ways, how it applies actually. So for what I am classifying, and I'm putting inverted commas there, is for an ordinary employee, the employer has a duty to assist, because the employer must be in a position to show what the employer has done to assist this particular employee to be able to do the job. So you can't just say, this person, can't do the job. Therefore, we employed this person. We knew certain shortcomings when we interviewed, and we were prepared to bring this person on board. So the company then has to ensure that they assist this employee to be in a position of being able to do the job at the required standard. And then, Jonathan, so let me make an example. In that case, let's say we are dealing with an HR coordinator, making an example. And then I get somebody else who is at management level. Management level is not going to be treated the same way as an ordinary employee, because when you're a manager, there's a certain level of experience that is required and qualifications, and we cannot possibly do hand-holding with a manager as we would, for instance, with an HR coordinator. So that distinction must be clearly visible, as to say, but this is an employee who is at a much lower ranked position, who can be handheld in this position. But with someone who's a manager or an executive, we cannot possibly be expected to treat them the same way as we would a much lower ranked.
In all this thing that we're talking about today, which is dealing with misconduct, there are operational requirements. So what are those operational requirements?
Yes. So that's the third reason for wanting to, or rather for a company seeking to dismiss employees. So dismissal for operational requirements is considered a no-fault dismissal. Similar to incapacity, it's also a no-fault dismissal. What no-fault means is that there isn't anything that the employee has done.
We just wake up and say, we're letting you go today.
So unlike we definitely don't do it that way. So definitely not. We will definitely be in trouble when we do it like that. The law does not allow us to do that. So it's so when we look at no fault dismissals, like for instance, now we are coming to operational requirements. The employee didn't do anything wrong. It's not like misconduct where the employee has done wrong. So with dismissal for operational requirements, it will depend on the facts for each case. So for example, operational requirements, also known as retrenchments, that takes place, for instance, due to a decrease maybe in demand for the company's services or products. Sometimes it may be that there's been an introduction of new technology. it could be financial management, or it could be reorganization of the company by the employer. So that's when then the process of retrenching employees come in. So when employees are retrenched, they are not retrenched because they've done something wrong, but it is because of those reasons that I've just mentioned to you, to say perhaps financially the company is no longer in good standing as it was before, or there's been an introduction of new technology and all of that. So the employees have not done anything wrong. It is because of whatever facts exist for that particular company having to resort to reducing the number of employees that they have in the company in order to ensure that the company continues to operate. So that is what we are looking at when we are looking at dismissing
we normally hear
employees
people talking
on
about
grounds
first
of
in, last out,
operational
and last in,
requirements.
first out when it comes to these issues, the operational operational requirements or retrenchment. Is this applied, or is just a principle that we an undocumented principle like a
So it will depend on the criteria that that particular organization uses to determine how employees will be retrenched, on what basis they are looking at. So there must be a criteria that is used. Sometimes they use the last in, first out, and they also look at qualifications, and they look at experience. So they look at all of those things. So it's not quite a simple process as one would think it is. So the criteria will determine how that particular, how the decision is made in terms of who and how this process will unfold.
Can we decide to say let's dismiss those who are getting paid a lot, and we left with who are not getting, those who are not getting paid there? Yeah. Okay.
No.
So it needs to be a fair process that is agreed by everyone in the industry.
No. Yes, definitely. The law requires that we do it in a fair process, because that particular process is quite a sensitive one. So we need to be mindful about how it is handled and ensure that it is done so fairly. Very important. Jonathan.
So is the company obliged? Let's say I'm a union rep who a full-time shop steward in a company, and we know the full-time shop steward, most of their job is to concentrate on what the union is doing in the company. Is the company obliged to keep me as the person they've been negotiating with, or I can still be retrenched?
So remember, when we are retrenching, we are looking at individuals, rather we are looking at positions, So at that point, it's not about whether I am a shop steward or whether I am a manager or whether I'm in this position. It's about what the company needs to continue its operations. And if I'm retrenched and it just so happens that I'm a shop steward, it will be treated as that. So the only thing is that it must be fair. Whether you're a shop steward or not a shop steward, all employees must be treated the same.
As we're going to close this interview, the last question then becomes, what then becomes the responsibility of the company? Let's say my day ends my last day is on the 30th of June this year. Does the company have an obligation with me to make sure that at least in the next 6 months or the next 3 months I've got an income, or is thank you, you've given us your service, bye-bye, meet again? Operational requirements, yes.
All right. So are you speaking in relation to operational requirements? Okay, yes. So what normally happens is that there will be a time frame of about a year. So, for instance, so it's not about the company ensuring that you've got a job within that period. What the company does is that, let's say things change, Jonathan, and the company, is doing well, and let's say I was occupying a certain position, that was, wherein being in that particular position, it resulted in my retrenchment, and they want to bring in that position. They can, of course, consider me and say, Kwazi used to be in this position. We can then, let her know that this position exists, and she can be interviewed like the others, and then appointed in that way. So there's absolutely nothing wrong with that. It is important that we do that. As a company, to ensure that
you're raising an issue,
and we can bring in these people
we're going to
when
close
there's an
down. So
opportunity
you
for them to
retrench me
come back.
today, 2 months down the line or a month down the line, you advertise that job. In other companies, what we see them doing, they will just change the title, but the job description will still be the same, and bring other people. Is that acceptable? Or can we take it for the company did not see that there will be a need for this new position at the time when they were retrenching me?
So, for instance, a company has to consider those people first. It's very important, Jonathan, because why would you get rid of me and then have the same position thereafter, and then leave me out? So it would be very unfair for companies to do that. So it's very important that companies do these processes in a very fair manner, Jonathan. So it would be very unfair for the company to actually do that. So yes, so companies have to look at those employees and give them first preference first, who were occupying those positions before considering anyone else outside, especially when the duties of that particular job are still the same. So it's very important.
Kwazi, thank you.
That,
I would have
consider
loved to
those
continue with this
employees
discussion, but our time is up now. Next week we will be touching on another issue that's got to do with the issues that HR. Hopefully by the time these discussions now, I will be able to go to any university and say, hey, do the recognition prior learning. I've learned I can be an HR person. Don't forget, Motomonte, you can still support us by subscribing and pressing that YouTube notification button. We want to grow this community. We want to help many people by a part of this community. Send us an email at podcast@calabashcommunitynetwork.co.za, podcast@calabashcommunitynetwork.co.za, or send that message on 0815813936. We'd like to hear from you. That, of course, get the WhatsApp number. Yeah, Rona. Thank you very much, and we'll meet again on the next episode. Okay. Take care.
Yes. Yes, thank you so much, Jonathan. Take care then.
Thanks for watching. Please share your comment and like this video. Help us grow our community by pressing the subscribe button and grow with us.